no hired gun in wig or gown. I just decode what's going down. With science, sons, and psyche flaws, I clarify and nothing more. While ordinary folk tell what they saw, I opine on facts through skills and law. For judges aren't all lab coat crew, nor juries trained in what I do. I light the path where truth may run, but choose the verdict, I choose none.
Welcome one and all. This is Declan O'Lula QC on The Law is My Oyster, the channel where we try and explain legal stuff and complex topics become crystal clear. Today we're diving into perhaps one of the most misunderstood figures in the courtroom, the expert witness. Not the dramatic TV version, not the hired gun, not the "I'll say anything for the right fee" myth, which is continuously propagated by dodgy TV series. We're talking about the real expert witness, what they actually do, what they're allowed to do, and just as importantly, what they absolutely cannot do. By the end of this video, you'll understand their true role, their legal duties, and why courts rely on them, but also keep them on a tight leash. Let's begin. An expert witness is someone with specialized knowledge or skill who helps the court understand matters outside ordinary experience. Normally, witnesses can only testify about facts they observed, but experts are different. They're allowed to give opinions because their training or experience makes them qualified to interpret evidence. Courts allow this exception because judges and juries aren't specialists in things like forensic science, medicine, engineering, accounting, psychiatry. Without expert assistance, jurors might find it impossible to reach a just conclusion where technical knowledge is required. So the expert's function is simple in theory. Help the court understand technical issues so it can decide the case, not decide the case themselves. That distinction is crucial, and we'll return to it again and again. The testimony of an expert witness is effectively in two parts. Before an expert is allowed to give opinion evidence on the matter before the court must recognize them as an expert. The court must qualify them. This happens during a stage called voir dire. The judge checks whether the witness truly has expertise based on knowledge, skill, experience, training, education. The lawyer calling the expert witness will typically present the expert's CV showing degrees and qualifications, professional licenses, publications, speaking engagements, relevant work experience. Opposing counsel can challenge that expertise during cross-examination, questioning credibility, reputation, or consistency of prior opinions. If the judge isn't satisfied that the witness is properly qualified to speak on the information needed by the court, then that witness is not allowed to testify as an expert. Here is the single most important principle. The expert's primary duty is to the court, not the party who hired them. Even though a lawyer pays the fee, the expert must provide independent, impartial, and honest evidence. They must consider facts that help and harm the side that instructed them. They are not there to win the case. They are there to help the court reach the truth. Courts have repeatedly criticized so-called partisan experts, experts who act like advocates instead of neutral specialists. Let's list their legitimate powers. They can give opinion evidence. This is the key exception to the usual rule that witnesses only testify to facts. They can explain complex technical material. Their purpose is to assist the court on matters requiring specialized knowledge. They can rely on professional expertise. Courts allow testimony when the subject forms part of a recognized body of knowledge that can assist the court. They can change their opinion. If new information emerges, they should revise conclusions accordingly. That's not weakness, that's professionalism. They can be paid. Payment does not automatically mean bias. Courts recognize fees vary widely depending on expertise and demand. This is where many people get it wrong. Experts have strict legal limits. They cannot become advocates. They must not act as cheerleaders for the party calling them. Their job is to assist, not to win. They cannot ignore inconvenient evidence. They must consider material inconsistent with their opinion. Selective analysis destroys credibility. They cannot exceed their expertise. Experts must confine themselves to their own field and clearly state when something is outside their scope. They cannot decide the case. They must not usurp the role of judge or jury. They assist fact-finders. They do not replace them. They cannot interpret the law. Experts cannot give legal opinions or tell the court what the law means. Law is for judges. They cannot mislead or exaggerate. Overstating certainty or presenting untested theories as established science is prohibited. They cannot hide conflicts of interest. Experts must disclose financial or personal connections that could influence their evidence. Failure to disclose may affect admissibility or weight. They cannot rely on unreliable science. Courts may reject expert evidence lacking scientific validity or peer support. A proper expert report must state facts relied upon and whether these were supplied or personally verified. List assumptions. Explain methodology in language that a jury can understand. Set out reasoning, again in accessible language. Acknowledge limitations in current research, methodologies, etc. Identify uncertainties. Transparency is mandatory. Experts must also follow procedural rules. For example, the defense must usually notify prosecution before calling an expert. See Section 34 of the Criminal Procedure Act of 2010. The expert's report must contain a clause that confirms the expert understands their duty to the court. Experts must cooperate with disclosure obligations, including adverse material. Oral testimony must be sworn testimony, so failure to take the oath or affirmation will make testimony inadmissible. Courts take breaches seriously. Possible consequences for the wayward expert witness include exclusion of evidence, reduced weight given to testimony, judicial criticism, disciplinary proceedings, negligence claims, wasted costs orders, and even prosecution for perjury or contempt. In extreme cases, courts have rejected expert evidence entirely where the witness failed to disclose materials relied on, didn't explain assumptions, lacked qualifications, or made wild allegations. Courts rely on experts, but they're cautious. Why? Because expert evidence can be powerful. Judges have observed that experts sometimes misunderstand their true function, which is to assist the court objectively, not to advocate. History shows that unreliable science can mislead juries. Persuasive experts can sound convincing even when wrong. Biased experts can distort truth. That's why modern courts act as gatekeepers, allowing only reliable expert evidence. These principles were clearly set out in what is known as the Icarian-Refer judgment, which is the seminal case in English law and widely adopted in other common law jurisdictions, including Ireland, that established the foundational duties and responsibilities of expert witnesses. Mr. Justice Cresswell identified these principles to address situations where experts acted as biased advocates rather than impartial advisors to the court. The Icarian-Refer judgment outlined several key principles for expert witnesses. Their primary duty is to the court, and their evidence must be independent and uninfluenced by litigation pressures. They must provide objective and unbiased opinions within their expertise. Experts should not act as advocates. Their opinions must be based on stated facts and assumptions, and they must not omit relevant facts. Experts must clarify if an issue is outside their expertise. If data is insufficient for a conclusion, they must state this and offer only a provisional opinion. Any change in a material view must be communicated to the other side promptly. All documents referred to in the report must be provided to the opposing party. Non-compliance with these duties can lead to the inadmissibility of expert evidence. The ruling aims to prevent experts from acting as hired guns for their clients, emphasizing that the duty to the court takes precedence over any duty to the client. The Icarian-Refer principles have been regularly cited with approval in the Irish Superior Courts. Most recently, in Duffy v. McGee, Noonan J. confirmed the following principles. The overriding duty of the expert is owed to the court and includes the duty to provide an objective opinion. The learned judge noted that It is unfortunately commonplace for experts to succumb to the natural tendency to put the interests of their own clients first, unconsciously or otherwise. Collins J. concurred with these statements and added, "The most significant concern about expert evidence relates to issues of objectivity, impartiality, and independence." The Superior Court Rules, Order 39, Rule 57-1, also provides guidance on the role of expert witnesses. It is the duty of an expert to assist the court as to matters within his or her field of expertise. This duty overrides any obligation to any party paying the fee of the expert. In summary, the absolute minimum threshold for any expert witness is that their evidence should be independent, impartial, objective, and unbiased. It must clearly be within the expert's area of expertise, and the expert must not stray outside their area of expertise. If they do, their evidence may be deemed inadmissible. The expert may ultimately lose significant credibility before the court, and in extreme cases, incur sanctions. An expert witness can be a tremendous assistance to the court, provided he or she observes these boundaries. This is Bebop coming to you from Waterford, and you have been watching The Law is My Oyster. Until next time, Slán.